This is Michael Popok, and it's time for Judge Luttig and Legal AF After Dark. We had the pleasure of Judge Luttig, conservative firebrand icon, constitutional scholar, commenting about the U.S. Supreme Court oral argument, and particularly whether the soul of America is at risk because of what he observed from the oral argument. Take a listen to my interview. You've just declared, I read it on your social media, that based on your observations of what happened at oral argument this week, the right-wing justices of the Supreme Court, if they rule to provide immunity to an American president for attempting to overturn a presidential election and cling to power, would, in your words, quote, cut the heart out of America's democracy and the rule of law and unsoul the nation. You love this country, the rule of law, the Constitution, and the Supreme Court's historic role in protecting our democracy from threats, foreign and domestic. Why are you so disturbed by what you observed at this week's oral argument?
Michael, the Americans' democracy and the rule of law are the heart and soul of the nation. And it's for our democracy and for our rule of law that America has been known as the beacon of freedom to the world for the past almost 250 years. The former president's effort to overturn the 2020 presidential election in order to remain in power and to deprive his successor, Joe Biden, of the presidential powers to which he had that he assumed by virtue of having been elected by the American people, which prevented, for the first time in American history, the peaceful transfer of power from one president to the next, drew into question the America's democracy and the rule of law. 3.5 years since January 6, 2021, the former president has continued to defy America and the Constitution. And he's unapologetic about what he caused on January 6, 2021. This week, the Supreme Court heard the former president's argument that he is entitled to absolute immunity, absolute presidential immunity from prosecution for those crimes, those grave crimes against the United States of America, and frankly, any other crimes that he may have committed while he was in office. In fairness, I suppose, to his argument, he argues that every president, all future presidents, should be immune from prosecution for crimes that they committed while in the office of the President of the United States. His argument, which gained some receptivity, it was at the Supreme Court this past week, is that unless a president, and in this case, he in particular, have absolute immunity for crimes that they commit against the United States of America, then he and they will be unable to effectively discharge their constitutional responsibilities to faithfully execute the laws of the United States. That's frankly a preposterous argument. It's never even been thought of until Donald Trump came along. Under the Constitution and laws of the United States, a president is never and must never be immune from prosecution for offenses against the United States once he leaves office and is prosecutable under the rules of the Department of Justice.
Judge, let me I tell you that You saying that to our audience is so powerful. To have somebody in a position formerly an appellate judge who knows this court well, who knows the people and the players on this court well. We're going to talk about people like Justice Gorsuch, Justice Kavanaugh, Chief Justice Roberts, and what you observed about how they were leading the conversation and the direction they were leading it and our democracy to. But first, I want to play a clip that I think you hit on right now, and for me resonated the most. It was Justice Ketanji Brown Jackson, who for me is becoming an intellectual heavyweight. She wasn't already, but she was when she got on. But she is quickly establishing herself, at least at the moderate and left wing of the court, of being an intellectual heavyweight. Let's listen to how she put her fears about a lawless president who's in office.
Justice Jackson?
So I think I now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act, is being necessitated by that assumption. Because of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be made.
Right, but I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law, and if they don't, they could be sent to prison, et cetera, et cetera. I guess you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
The seat of criminal activity in this country. Do you agree with Justice Jackson?
Well, I absolutely do, Michael. This entire distinction between official acts that might give rise to criminal prosecution and private or personal or candidate acts that might give rise to criminal prosecution is a tempest in a teapot. For almost 250 years since the founding of this nation, this line has never been suggested, let alone held to exist by the Supreme Court of the United States. But I'm so confused by this for this reason. As Justice Jackson was saying, if anything, a president should be accountable for criminal acts taken in his official capacity as President of the United States of America. I, of course, agree that he or she should also be accountable for private or personal and of course, candidate acts. But it's counterintuitive to me, Michael, to argue, as the former president has done, and as the Supreme Court is considering, that the President of the United States should not be prosecutable and therefore should be immune from prosecution for criminal acts against the United States committed in his official capacity as the President of the United States. I simply do not get it, but there's no question at all that the Supreme Court is considering just that. Now, I will add this. The Supreme Court is concerned about the criminalization of presidential acts and actions that ought not be criminalized. I understand that concern. That's not the case here. The Supreme Court has before it one single case that presents one single question for decision, and that is whether a president of the United States can seek to overturn an election that he lost fair and square so as to remain in power, depriving his successor of his rightful power by virtue of having been elected by the American people, and at the same time preventing the peaceful transfer of power for the first time in American history. That is the narrow, specific, and profoundly important question before the Supreme Court today. And it's the only question. And during this week's argument, which lasted over 2.5 hours, the Supreme Court barely even discussed that issue, at the same time discussing everything else under the sun that is utterly irrelevant.
Well, welcome back. We do interviews like that as a special edition of Legal AF as much as we can, and we're always thrilled to have Judge Luttig join, speak to our audience from the heart in a no-holds-barred interview format. If you like that kind of analysis, you've come to the right place. I think the only place on YouTube and on the internet, the MeidasTouch YouTube channel. Free subscribe, help them get to 3 million, and then you can join me, Ben Mysalis, Karen Freeman-Ignifilo, on Legal AF, the podcast at the intersection of law and politics, on Wednesdays and Saturdays at 8 p.m. Eastern Time, and then on audio podcast platforms wherever you get them from. So until my next hot take, until my next Legal AF, until my next interview, until my next Patreon exclusive content, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.